Hello, welcome everyone. My name is Kate Gaziano, and I'm the Vice Chair of Speakers for the Federalist Society here at the Antonin Scalia Law School. On behalf of the school's Federalist Society chapter, we're so delighted to be partnering with the Pacific Legal Foundation to put on this event, and we're so pleased to welcome everybody here today for today's debate and oral argument debrief. I also want to welcome the folks from the Federalist Society's National Board who are filming today's debate so that those who weren't able to join us here can enjoy the discussion later. Two housekeeping items: please go ahead and silence your phones so nothing disturbs the filming. And if you're a student, we're passing around an email sign-up sheet, so we'd love you to add your email and we can let you know about more events like this in the future. In a minute, Christina Martin with the Pacific Legal Foundation will introduce our panelists and honored guest. Christina is a lawyer in PLS Florida's office and was second chair for Knick in the Supreme Court this morning. After the panelists deliver an opening statement and a brief rebuttal, I'll recognize your questions. Christina, the mic is yours.
We have an excellent panel here today. We will hear first from Mr. Dave Breemer. Dave is a senior attorney with the Pacific Legal Foundation. He had his second Supreme Court oral argument this morning representing Knick in Knick versus Township of Scott. This case asks the Supreme Court to open federal courts to Fifth Amendment takings claims against local government by overturning part of the 1985 decision Williamson County Regional Planning Commission versus Hamilton Bank. Dave has worked to reverse that decision for more than a decade and has written a number of law review articles on the topic that he hopes will soon be mooted by a win in this next case. Next, we have Lisa Soronen. Lisa has been the executive director for the State and Local Legal Center for 7 years. The SLLC files between 8 to 12 Supreme Court amicus briefs each term on a broad range of issues affecting state and local government. The SLLC filed an amicus brief in support of Scott Township, and we're glad she's here today to share her perspective on the issue. And seated in the middle is Ilya Somin. He teaches constitutional law and property here at George Mason, and he is the author of Democracy and Political Ignorance: Why Smaller Government is Smarter, and also The Grasping Hand, Kelo versus City of New London, and the Limits of Eminent Domain. Professor Somin supported Ms. Knick as amicus. And finally, I'd like to acknowledge a special guest here today, Knick. We would not be here today discussing whether the Supreme Court will be overturning a 33-year-old precedent without her persistence. So thank you for joining us, Rose, and thank you for your persistence. Now let's hear from the panel. Dave?
Okay, thank you, Christina, and thank you for having me. Thank you, Rose, and Federalist Society and Pacific Legal Foundation for hosting this event. To talk about this case, I want to go back a little bit and make sure the issue is properly framed. So, as many of you probably know, when the 14th Amendment was enacted, a law that we call 42 U.S.C. Section 1983 was enacted along with it to enforce the 14th Amendment, and that law says that federal courts, that a person can bring a claim of a violation of a constitutional right in a federal court against any person, which includes a local government. So that was an 1871 law that opened up, okay, hello, is that better? That opened up due process claims, seizure claims, equal protection claims, that if you have a local government that's violating your right, you could go to a federal court. And the reason for that law and that change in our system was fear that local courts would hometown you. There'd be bias against you. As a person originally, it was called the Ku Klux Klan Act. There'd be bias against you in the local courts, and you need to go to a federal court, you get a more objective hearing. And so under that law, Section 1983, up until 1985, if you're a property owner or a person with a free speech claim, or you got a due process claim, or if you have a seizure violation, you have a state system that will protect you. You could go to a state court and protect your federal rights there, but you also have a right under Section 1983 to go to federal court and get your rights protected there if you believe that the state system might not give you a fair shake. It all worked fine, more or less, until 1985, when the Supreme Court, in the decision at issue in this case, called Williamson County, held in what Justice Kennedy called dicta, that a property owner cannot file a claim that their property's been taken and they're owed just compensation until they first go to the state courts and give the state court the first shot at it. Doesn't sound so bad at first, but when you combine that with another rule that some of you are learning in, well, you're going to learn it if you haven't. Res judicata, you don't get a second bite at the apple. So when you go to state court under this Williamson County rule, you can't go back to federal court. So you're effectively relegated to the state courts. And so this change, this 1985 decision, was a sea change in the law, in the federal-state balance for one class of constitutional plaintiffs. People who believe, like Ms. Knick, that the government has taken their property through regulation or something like that. Other people who have free speech claims, people who have a due process violation claim, people who say their property's been seized, people who say that they have a free exercise problem, they can all invoke Section 1983, go right to federal court, get an up or down ruling. Yes, the government wronged you. No, it did not, but not property owners. They're stuck in a state court system that that oftentimes is subject to the very biases that the 14th Amendment and Section 1983 were designed to get out of. So Ms. Knick, Rose, she has the township, as you know, come in 2012 and pass an ordinance that says that all private property that contains a cemetery of any size, anywhere, must be open to public access 7 days a week, 365 days a year, and the township has a blank check to walk on any property to search for these cemeteries. Now, I don't know if you know about Pennsylvania, but there's no law against backyard burials. So these small family burial sites all over the place. We don't know if there's one really on our property, but they're all over the place. So the township declares your property is open to public access. She wants to go to federal court, but can't at first, goes to state court. The state court says, no, we're not going to hear your claim right now. So she does file a Section 1983 in federal court. Federal court says, no, we can't hear your claim right now. You should have gone to state court and filed a different claim. And 5 years later, still an easement on the property. No up or down ruling from anyone. Is this a taking or not a taking? And because of this decision, Williamson County. So the issue that was before the court today was whether the court should change that and go back to the system that existed for 100 years before Williamson County, more or less, where people like Rose could go to a court, get an up and down ruling that the property's been taken just like any other constitutional plaintiff. And we're hoping that the answer is yes. It's not going to change the state-federal balance. It's actually going to correct it and return it to what it was always intended. You can choose to go to a state court if you have a constitutional claim, or you can choose to go to a federal court, and they're both capable of handling it. But to force one class of people who happen to own property, to not be able to protect their federal rights in federal courts treats them as second-class constitutional citizens. And the worst part about it is there's no good reason for that. No one has ever identified a logical or doctrinal basis for sending property owners only to state courts when they want to protect their federal rights in a federal court. So I'm going to end right there. I think that's about 8 minutes, maybe less.
So I am up next. You guys can hear me, right? I'm Lisa Soner with the State and Local Legal Center. Thank you for having me. And as my introducer said, my organization filed an amicus brief on behalf of the Township of Scott. So my remarks are going to focus a good deal on what our amicus brief argued before the Supreme Court and a similar amicus brief from the state of California which was signed on to by 17 or 18 other attorneys general. But before I talk about that, I want to talk a little bit about some big picture thoughts. I went in the argument with five objectives, 5 things that I wanted to see. First, I wondered, what would Justice Gorsuch do or say? This is his first property rights land use case. Predictably, from my perspective, he looks like he'll vote for or against the Township of Scott. The issue that our amicus brief focused a lot on was the idea that there's this catch-22, that if you have one of these cases, you can't file in state or federal court, or you'll end up being kicked out of both of them, or you'll have nowhere to go. And I wondered how much of the court's time would be spent on that, and if the justices would be worried that there was literally no forum for anyone. And there wasn't a lot of emphasis on that in the oral argument, which I took to be a good sign for the position that our amicus brief had. I thought the most interesting amicus brief in this case was actually filed by cemetery experts. When I first read this case months and months ago, I heard what the Township of Scott did, and I think like a lot of people, I rolled my eyes. I mean, they're really gonna make someone's land open 24/7 for a cemetery? I mean, really? And then I read this amicus brief that talked about the fact that historically, per the common law, people were buried kind of all over the place, and people have visited relatives, and that's kind of a part of our legal tradition. Just didn't happen to know that myself. I also wondered, would this court stay focused, or would they get really sidetracked on some off issue? I thought they were pretty focused on the basic issues of the case. Then, of course, I wondered, would it look like it was going to be a 4-4 split? And I think there's room to say 5-3, 4-4, our side, the other side. I think all that's on the table. I was encouraged from the perspective of the Township of Scott that the Chief Justice seems somewhat amenable to our position. Other couple interesting things to think about in terms of this case. The petitioner's side briefs were filed before Justice Kennedy announced his retirement. Everyone was writing for Justice Kennedy. It's worth thinking about, is that a good idea to write for one justice or not, especially when we saw the Chief and Justice Kagan maybe not in their traditional roles. The respondent side briefs were written with Judge Kavanaugh in mind. That didn't work out either. And the other thing from the perspective of my organization is this. The Supreme Court has taken 3 petitions this term so far where they are explicitly deciding whether or not to overturn precedent. 3 petitions. All these cases affect state and local government, which just happens to be a coincidence, I think. The Roberts Court is sort of famous for not overturning precedent. They did twice last term in pretty big cases, but that's not kind of what the Roberts Court does. And so I'll be curious to see how that plays out. And I do think if there's something that holds the Chief back, it's going to be stare decisis. So those are some sort of interesting things to start out, just sort of in the big picture, regardless of what our brief actually said. So our brief made 3 arguments. One, we tried to say, look, there is a forum in these cases. It's the state forum. But court, don't get the idea that there's nowhere for plaintiffs to go. The other argument that we made was that even though these violations are only heard in one court, that state court is a good place and a logical place for these cases to be heard. So, like I said, if there really was no forum for these cases and they couldn't be heard in federal or state court, I think that would be fairly alarming. And what our amicus brief did is we examined the cases that the other side had said, look, is there really a forum for these cases in federal or state court? And what we determined was in a number of cases, the plaintiffs didn't follow the process they were supposed to follow. They didn't start in state court like they were supposed to. In some instances, the defendants, so the state and local governments, remove the cases then to federal court. And California went out on a limb and said, we think that practice is bunk. We don't think that it should be that the state and local government can come in and remove a case to federal court when it clearly doesn't belong there. Our brief didn't go that far, but I think that's probably a position we basically agree with. And in some instances, when cases were removed to federal court improperly, the federal judge would just sort of send the case back to state court. So the point we were just trying to make was there is a forum for these cases. And another thing, too, is that Williamson County had said, look, the state procedure has to be, here are the terms, reasonable, certain, and adequate. And sometimes lower courts have said, this state procedure actually isn't reasonable, certain, and adequate. So that becomes another sort of check on what's going on. The Chief Justice asked questions about that. I think the argument that got the most attention in the oral argument was the argument that David started with or talked more about, which is this argument. So if I have and I like to make it sort of simple. If I have a First Amendment claim, if I have a Fourth Amendment claim, if I have any other claim, I can go immediately to federal court. I don't have to go to state court. So why is it that a takings claim should be different? And what our amicus brief argued and our amicus brief argued was that the compensation is actually an element of the claim. And that element has to be decided first, and it can be decided in state court. And then it's state court that sort of determines what exactly the violation is, if there is a violation. And a simple way of looking at this is sort of this. In most instances, it's not obvious that a taking has actually taken place. And like I said, in my own impression in this case when I first read it was, of course a taking took place. But then when I read the Secretary's brief, I was like, maybe not. So the point, Justice Alito actually asked in the argument, the lawyer for the Township of Scott, is there a taking or not? And she said, I don't know. He said, I want you to go back to your office and think about it. And I was like, whoa. But her point, which is the one that I agree with, was like, this hasn't been adjudicated. It hasn't yet been determined. So you only get just compensation, right? You only get just compensation if there has in fact been a taking. So that's the difference, that this state process is designed towards first determining whether or not there was in fact a taking. And then after a result of making that determination, then you get your compensation. And one of the points that the state brief made, we didn't make this as much, was that there are a lot of federal claims that are heard in state court. The state of California talked about domestic relations, parental rights, probate law, and tax. And there was some discussion in the oral argument about the fact that that was true. We also talked about in our brief the fact that there is probably no law that is more defined, that is more like state-centric, that is more classic state law than property law, and that's a reason why these cases should be heard in state court. And as a result, Justice Breyer pointed this out, of Williamson County, what has happened is that a lot of state courts have become real experts in this law and really sort of understand it very well. And another point that we made in our brief that the Chief Justice picked up on is that, one question you have to ask is, do the federal courts really want to be inundated with these very tedious, very detailed, very state law driven, very complicated takings claims? And the Chief Justice actually said, you're not going to be the one that gets the letters when all these district court complains about all these state takings claims that we have to hear now. So those are the primary arguments that we made in our brief, along with the state of California.
Can everyone hear me? So I'd like to start by thanking Federalist Society and the Pacific Legal Foundation for organizing this event, and all of you for coming. I certainly didn't expect such a big crowd for such a technical and in some ways very procedural case, but I'm glad you came, even if it was only for the free food. Perhaps the panel will entertain you as well. So I'm going to start out by briefly talking about what the Williamson County Doctrine is, then we'll discuss why it's very badly wrong. It's a big outlier in constitutional law. I'll also talk briefly about what this doctrine means in practice, how it causes harm in the real world, and if time permits, I have some very brief thoughts about the oral argument. So normally, if you believe that your constitutional rights under the federal Constitution have been violated, you can go to federal court and file your claim. And you can go to federal court in the first instance. You don't have to first go to state court and get some kind of decision. But under Williamson County, you can't do that for takings claims. You first have to go to a state regulatory agency if one was involved and get a, quote, final decision from them. And then after you've gone through that bureaucratic rigmarole, you have to go to a state court and exhaust state court remedies, potentially even all the way up to the federal Supreme Court, to the state Supreme Court. And then after that, if you want to go to federal court, then then you're out of luck because of these preclusion doctrines which say that if an issue has already been decided in state court, you can't just take it to federal court afterwards. And that's the catch-22. It's not that there's no court at all where these claims can be heard. They can be heard in state court in most cases. It's that before you go to federal court, you have to first go to state court, but then the very act of going to state court prevents you from getting into federal court later. That's a catch-22 if I've ever seen one. Now, as I mentioned before, there's no other constitutional right that gets treated this way. So is there a justification for this double standard? And the answer is no. The standard argument that is most often offered is the idea that, well, with a takings case, there's not really a violation until it's been determined that they're not going to compensate you. And you don't know for sure that the state won't compensate you until you've gone through these state court proceedings where they decided that there won't be a compensation. But as the Chief Justice pointed out in oral argument, in reality, the violation of the takings clause starts as soon as your property has been taken. If they've taken it but haven't paid you, they've taken property without just compensation. And there's nothing in the Fifth Amendment which says, well, you can take property without compensation so long as as long as it only goes on for a little while, or even a long while. In this case, it can go on for many months or even years before the state adjudication is over. It says if you've taken property without just compensation, that's a violation. And so the violation happens in the first instance. Now, it may be true that a state court or a state bureaucracy later down the line might remedy the violation by saying, yes, actually, we are going to pay you. But of course, the same thing can be said for any other constitutional right. If a state or local government says, we're going to censor your speech, but then you go to a state court and say, no, actually, we're not going to do that, or the bureaucracy changes its mind, then that violation can be cured that way too. But nobody says that means you can't bring those cases in federal court. The second rationale which is offered, you just actually heard from Lisa, is that, well, the state courts are the real experts on this stuff. Property law is complicated. It's really difficult. Those fuddy-duddy federal judges don't really understand it, but the states do. Now, as a property lawyer, I certainly agree that part of the way I make my business is by teaching this complicated property law stuff, but I don't agree that it's all that unique. You can say the same thing for virtually any other area of law where states and local governments are involved. If you have a Fourth Amendment case, a First Amendment case, a Second Amendment case, pretty much any other kind of case, many factual and even some legal determinations involved will involve various local circumstances the local and state judges might know more about than federal judges, but we don't say that means those cases should be barred from federal court. I would add also that part of the whole point of incorporating the Bill of Rights against state governments through the 14th Amendment was to ensure that there would be a federal remedy against state courts and against state and local governments, because those governments were in many ways running rampant over various basic constitutional rights, including property rights, which is actually a central concern of the framers of the 14th Amendment. In the first instance, they were concerned about the abuse of the rights of recently freed African American slaves, and also of whites in the South who had supported the Union during the Civil War and thus were not popular with the white majority in those states. But more generally, it was to protect these rights for all people and to ensure that there would be a federal floor. And this gets us to the question of, well, why should we even care about this? Does it really matter whether it goes to state court or federal court, or is this just the kind of thing that lawyers like to argue about, but normal people don't really need to care? And in some cases, you probably don't need to care. The outcome may very well be exactly the same, whether it's in state court or in federal court. But as David suggested earlier, there are going to be situations, particularly cases where the law is ambiguous, where the state courts may well be biased or prejudiced in favor of state and local government, because often they're part of the very same political machine, the same political coalition that imposed these regulations in the first place and doesn't want to pay. today. This is particularly likely in the many states where state judges are elected. More generally, as I suggested before, we want a uniform federal floor for the Bill of Rights. That's the whole point of having a nationwide Bill of Rights, and the option of going to federal court helps to ensure that. As to the oral argument, I think it's far from clear what's going to happen. I do think the 4 conservative justices very likely in one way or another will vote with Ms. Knick. I think also it could be a 5-3 in favor of her if Elena Kagan votes as it seems like she might, because she said that while she may sympathize with some parts of the township's argument, she cannot get over this point that the system closes off access to federal court for these sorts of cases entirely. She even asked specifically, well, how do I get around that? I think the answer is going to be that you can't get around this without either overruling Williamson County so that you can just bring these cases at the front end to federal court, or really jiggering significantly with other kinds of doctrines to enable them to go to federal court after they've gotten a final decision from state court. And so if she's serious about what she's saying, she's going to have to pick between those 2 options. There is still a possibility there will be a 4-4. In that case, it's also possible the case will be re-argued when and if we do have a 9th justice, whether it's Kavanaugh or someone else. And on that point, your guess is as good as mine. So I'm happy to stop, but I very much look forward to discussion and questions. Thank you.
Wonderful, thanks so much. We're going to allow the panelists to do a brief rebuttal, and following that, we'll have a question and answer session.
Okay, really quickly. So state court systems for deciding a taking vary from state to state, and they are often more complicated than just going to a federal court and asking a judge to rule, is there a taking, is there not a taking? I get compensation if there is. I don't if there's not. State court systems in California are different from the state court system for proving a taking in Pennsylvania. And it's more burdensome, often, in some states to go through that system. So then you get back to the question, well, a property owner wants to go to, like Ms. Knick wants to go to a federal court. Let me put it really in context. Every reason that is trotted out for why a person can't go to federal court and claim there's been a taking within the meaning of the Fifth Amendment would apply to every other constitutional provision. If you have a seizure, why do you not have to go to state court to determine if that's reasonable before you have a chance to go to federal court? If you have due process deprivation, why shouldn't I have to go to state court and let them have a shot at it first before I go to federal court? It's the same thing for a takings claim. It says taking without compensation, just like seizure says unreasonable seizure, due process, with deprivation without due process. A person who has a seizure claim or a due process claim or a takings claim should be allowed to protect their federal rights in federal court. That's a basis of our system. I'm almost done. And to deny a person like Ms. Knick the ability to get that ruling says something about, well, maybe property is less important somehow than free speech rights. And I don't understand that, or maybe it's less important than equal protection. If you don't have property, you don't have privacy. The whole point of private property is privacy, private property. If you don't have property, you can't control your wallet. If the government can take your wallet, it can tell you to shut up. It's got control of you. If you don't have property, you can't protect yourself. So the takings clause is designed to make sure that the government has a very, very good reason, is going to pay you when it comes in and takes your property. Otherwise, it shouldn't do it because it's going to affect your other rights. And if you can't protect those rights in federal court, well, then you're going to the local judge, who knows the local lawyers, who knows the local mayor. That's why the 14th Amendment, which opened up the states to the federal Constitution, was enacted. So they couldn't do that. I'm done.
So I just have a couple of points to make in response to what my colleagues have said. So I think one thing to think about when it comes to property rights is they are never absolute. Now, it's true that no rights are absolute, but they have a special limitation that doesn't apply anywhere else in the Constitution. And that limitation is that it's a right to not have your property taken without just compensation. So another way of looking at this, I think more simply, is that, what happens to land when it is taken is it's used for the public good. The idea is not here that the government takes your property, burns it down, and laughs at you, and then refuses to give you money. Rather, the idea is that if your property is taken, you are given compensation. So this right is a little bit different than the other rights in the Constitution because we all, in some sense, communally own all of the land. That's maybe a little bit of an over-the-top statement, but I'm just saying property rights are different because of the communal nature in which we live, whether we want to or not. The point on whether state courts are a good place for these claims or not, it's kind of an interesting question because it's hard to sort of objectively determine, did someone really get a fair shake in state court or didn't they? California's amicus brief tries to take this on by saying, look, we can cite to cases where property owners win. We can cite to cases where property owners lose. So like I said, it's a hard point to sort of prove. So Justice Breyer's main point in the oral argument, I don't know if I can quote him exactly, but it was something to the effect of like, what's the real harm? I mean, you get a venue, you get a place to bring your case. I think it was maybe, if it's not broken, don't fix it. The idea that we've existed in this system for 30 years and the world hasn't come to an end, those kind of things are compelling for a court that cares as much about being static as it does about being right. And the fact that people do have a remedy and rights have been realized, I think, is important to the court. Another thing that I learned during the oral argument that I thought was interesting was I didn't know that much about Pennsylvania's procedure. I'd have no reason to know. But it does sound like it's very generous to property owners. If you win your claim, you get your experts paid for. The lawyer for the Township of Scott talked about that in detail, and I thought it was pretty. I thought that was pretty interesting. The other thing I'm going to leave for the professor is the Solicitor General made an argument about a statute that's called 1331 that I think is sort of a jurisdictional statute. And like I said, I'm going to leave it for someone else to tackle that. And it's always interesting when the Solicitor General gets involved and does something different in their brief. So this 1331 business, whatever it might be, he's going to explain it. None of the parties brought that up. None of the parties were really were interested in it at all. But the Solicitor General is not any amicus. My organization, as credible and as wonderful as I think it is, does not rank with the Solicitor General's office. They're called the 10th Justice. They have their own office in the Supreme Court. So if the Solicitor General wants to pull something out of a hat and say, Supreme Court, you need to look at this, they're going to look at it whether they want to or not. That came up in the oral argument where, a couple of the justices expressed, it's the guy with the pictures, or the camera is making me nervous, expressed some skepticism about an argument that they'd never heard before. And I even, to prepare for this, I even put in the find function, how many times did they refer to 1331 in their brief? And it wasn't even a whole lot. It wasn't like their entire brief or something. But that's another thing as you think about being lawyers and working as a lawyer, like when to make a unique argument, in one context to make it, how well will it be received? So that's just kind of an interesting practice point. And I guess where I'm going to end is sort of where I started, which is I'm going to be very curious to see what the Chief Justice does in this case. He started out right out of the box having a question for David right away. And I think, and I could be wrong about this, that the Chief Justice, especially since Justice Scalia has died, has really sort of taken a more active role in oral argument and has asked questions on both sides, which makes him harder to read and less fun for those of us who have to listen to him all the time. Because you go to an argument, you ask questions on both sides, you kind of can draw no conclusions. I think the other thing that's sort of worth thinking about in terms of him was that last term he dissented in a case involving stare decisis. It was called South Dakota versus Wayfair. It has to do with the Dormant Commerce Clause. And he basically said, I kind of think that this old precedent that I want to keep was wrongly decided. But I don't care. I'm just going to keep it because we've built our economy around this wrongly decided case. So we've lived with it. We're fine with it. Let's just kind of go forward. He could use the same rationale in this case and say, Williamson County, kind of weird dicta. Maybe not the fairest result or the right result, but look, we've lived for it this long. There is sort of a forum. why don't we just stick with that? And, in terms of the bigger picture, a lot of people have wondered, what will the Chief Justice's role be now that we're facing the prospect of having these 5 conservative justices appointed by all conservative presidents? And, the Chief Justice, not to go off on too many tangents, just like everyone else, saw the very partisan remarks that Kavanaugh had made. I knew Kavanaugh was going to come up here somehow. I'm just sorry I happened to bring him up. And I think for those of us who believe, and I think most of us do, that the court or the chief sees himself as having this role of protecting the institution, not making it look partisan, being incremental, keeping stare decisis, that he's faced with some quandaries. And those quandaries aren't coming, they came today. They're coming this term. These problems are very real for him. And it is true in the Janus case that he was willing to overturn precedent. But I think he's going to be sparing. And I'm probably wrong, because if I say something in public and it's recorded, it's almost always wrong. But with that, I'm going to leave it for the professor to talk about 1331. Or not.
Thanks for that. So I just want to talk about 2 issues, and we'll very briefly touch on Section 1331 after that. But first, I want to talk about this argument that we just heard, and also that we saw during the oral argument as well, that maybe it really doesn't matter. The states have these great procedures. The property owners will be just as well off in state court, so what are they complaining about? I don't doubt that Lisa is sincere in making this argument, but if her clients, the state and local governments, really believe that, they wouldn't be taking the position that they are in the case. They would say, go ahead, go to federal court. Your odds of beating us will not be any better. But on the other hand, those feds will have to pay for the associated court costs and the like. We, the states, will save money. It'll be great for us to fob these cases off on the feds. The reason why they want these cases to go to their own courts is because, at least in some of the states, not in all, but at least in some, they have a better chance of winning against the property owners, and also they sometimes have more convoluted and expensive procedures that make it harder for the property owners to fight the case. That's what's at stake here. That's why they're resisting it so hard.
So hold on, before you get to 1331, this is proof a professor should never have the last word.
Okay, well, it's not an accident that I arranged to have it. So the other issue that I wanted to talk about is this question of stare decisis. The court actually has a doctrine for when precedents should be overturned and when they shouldn't be. You might say it's a precedent about overturning precedent. It's far from a model of clarity, but what there is suggests that Williamson County should be overturned. First criterion is whether the reasoning of the case in question has been seriously questioned. There are very few cases in takings law that have been questioned more severely by more people than this one, and that's because its logic doesn't make any sense. So that criterion points in favor of Knick. A second one is whether there are reliance interests. That is, are people relying on the precedent? And to some extent, they are relying. But the reliance interest that the state and local governments might have is an interest in winning takings cases in their court that they would lose in federal court. And there's in doing things that federal courts would rule to be unconstitutional if the federal courts could hear them. An interest in engaging in unconstitutional activity is not generally the kind of interest that the Supreme Court would want to recognize. And then there's also an issue of whether the case is unworkable, on whether it's poorly reasoned and the like. I think there's no reason to believe that overturning this case would make things less workable. In fact, it would make them more so. There is perhaps the risk there would be more litigation in federal court, but that can be said for any greater increase in protection for constitutional rights. They said this about Brown versus Board. They said this about the incorporation of various parts of the Bill of Rights. If the court genuinely believes that this is a right that deserves protection, are not going to be stopped by this. Finally, since you sort of compelled me to talk about Section 1331, I will for about 30 seconds. Frankly, it seemed to me from the transcript that very few people in that room understood what the Solicitor General was talking about when he discussed Section 1331. Not even sure he himself understood what he was talking about. And it seemed to me that the justices were very unlikely to go for this particular argument. In fact, at some point, said, okay, fine, I'm going to move on from this argument and talk about something else because it doesn't seem like it's attracting that much interest. So I highly doubt that this argument is what will determine the case, but if people do want to talk about it further in the remaining question time, I will attempt to do so. Thank you.
Thanks so much to all the panelists and Wells. I hope you enjoyed your suppressed sneak peek. We're going to start the question and answer portion now. Alec, right here, is going to bring the mic to you. If he sees that you have a question, please wait to get the mic so that we can record your question for the national audience. And then please ask a brief question directed at any or all of the panelists. Thank you.
Thank you. Hi, this is for everyone. Why is, maybe I don't understand the procedure, but why is this an ideological split? Why is this falling along? Why can't, like, for instance, why wouldn't, for instance, Gorsuch and Ginsburg agree on this? Why is it falling?
They will. They will.
So that's actually a good question. In many property rights cases, they do tend to fall on left-right lines. In that respect, it's not surprising, even if lamentable. However, in more procedural property rights cases in recent years, many of the liberal justices, and sometimes even all of them, have in fact voted to crack down on egregious procedural barriers to bringing property rights claims. In this case, too, I think, as I said before, I think there's a decent chance that Kagan, at least, will vote for the property owner. Ginsburg and Breyer both were on the San Remo case in 2005, where they passed up the opportunity to join a concurring opinion that was actually joined also by Justice Kennedy, among others, that argued for reconsidering Williamson County, so they may feel bound by their previous views. Sotomayor, of all the present justices, I like some other aspects of her jurisprudence, but she is the one most consistently hostile to property rights, so it's not entirely surprising that she would be there. But I do agree that it's in some ways lamentable that there is as much of a left-right split on this issue as so far that seems like there might be. I don't think it has to be this way, and in recent years it hasn't been that way on procedural takings question as opposed to substantive ones that ask the question of, is there a taking? Right, that's what the cemetery's brief goes to. It says maybe there isn't really a taking because under traditional common law, you don't really have a right to exclude people from a cemetery on your property. Anyway, that might be true, I don't know, but that's not actually the issue directly at stake in this case. I know if you...
Just to respond very, very briefly, maybe even in one sentence. This is perhaps a cynical answer, and with law students, it's not so great to be cynical, but I think, part of the sort of more conservative agenda is, in the playbook on the first page is property rights.
Any other questions?
This is not for anyone in particular, but a lot of you talked about the degree to which a lot of the justices wanted to maintain precedent, but you also mentioned how the decision with Williamson County was just dicta. So I was wondering if that would affect the justice's willingness, perhaps, to overturn something that's not holding anyway.
You can have that.
So while Justice Kennedy, now departed from the court, had at one point described it as dicta, I'm not convinced that it is. It had in fact been treated as a holding by lower courts. I did, for the reasons I mentioned earlier, I think this is the kind of precedent that by their own standards they should be willing to overturn. I also think it's unlikely they would have taken this case if they didn't want to seriously consider overturning, or if there wasn't a constituency for that on the court, because this doesn't sound like the kind of case that they would take just because of its enormous intrinsic importance, with all due respect to Ms. Knick. Similarly, and to the township. Similarly, it's not a case I think that they would have taken just because they enjoy hearing these kinds of procedural takings disputes. But it is true, stare decisis does carry some weight, and clearly I think it is certainly influencing Justice Breyer in his thinking. The Chief Justice, I think it's more likely than not, to my mind at least, that he will, at the end of the day, vote to overturn this thing, or at least pare it back significantly.
Can I follow up on that? Is that okay? It's just, we're describing this dispute as procedural in a way, but this is one of the most important takings clause precedents the Supreme Court has ever met. You look at Miss Knick right there, and then multiply her by hundreds and hundreds and likely thousands of property owners who have never had their day in court when their property has been invaded. And the reason is the federal court can't figure out under Williamson County if it should be in state court, and the state court can't figure out if it should be in federal court. So you get a ping pong effect, and the property owners, their money is wasted, the time is wasted, it's justice delayed, it's justice denied, and so you have over 35 years. I don't know how many PLF we've seen them come and go, and they lose, and they can never get a ruling up or down or not. So your rights, constitutional rights, are no better than the court's willingness to protect them. It's a piece of paper. If you can't go to a court to say, yeah, I'm going to enforce this piece of paper, it's a piece of paper. So it's not just procedural. It's is somebody going to protect my rights? For her, the answer has so far been no. 5 years. But she's just won. We're 35 years nationwide, 50 states of this going on.
It's super addictive.
Alec, I think Taylor has her hand up.
So I guess this is for Professor Somin, since you made the point. You said that state courts would prefer it to go to federal court if they thought it was more beneficial in that respect, because then the federal government has to pay for it. On the flip side, could the federal government want it to remain in state court to avoid the burden of paying it?
Yeah. So it's an interesting question. My point was not that state courts would prefer it to go to federal court. My point was that state governments and local governments would prefer it to go to federal court if it really were the case that it made no difference the outcome, and if they could have just as good a chance of winning in federal court, because then they wouldn't have to pay for it. It may be true that Congress might prefer not to pay for this. It also may be true that some federal judges would prefer, who don't like these sorts of cases, would prefer that they weren't in federal court. That's certainly a possibility. But my point simply is that when you see all of the state and local governments, not all of them, but many of them lining up and saying, we really want to be able to hear these cases in our own courts, then that's a strong sign that they want to do that because they think it'll give them a better chance of winning the cases. It's unlikely that they want to do that just because of a deep love for the doctrinal features of Williamson County.
I think we have time for one more question.
L1, this is a question for all members of the panel. Do we have any data suggesting that state courts are either less professional or more corrupt as compared to federal courts?
We don't have nearly as much evidence on these sorts of things as we would want. I think, it's been a while since I've looked at this, I think there's a wide variation in the professionalism of state courts. There's also a wide variation on indices of corruption between states. So some states score really well on these metrics, others less so. What I was pointing to, though, was not that they're corrupt in the sense that they'll be bribed to decide in a particular direction, but rather that they can be influenced by the fact that they're part of the same political coalition as the state and local politicians. And it's not that they say, well, I'm deliberately being corrupt and ignoring the law. It's that they're pre-selected for beliefs and views that are similar to those of the dominant political coalition in their state, and they can be completely honest and completely technically professional, but still this could be a factor. Also, the state, as was mentioned earlier, can set up procedures which are Byzantine and difficult to get through.
Fortunately, do you want to go?
I was just going to say again, take a look at the California Amicus brief and read the section that they have about how they feel that the state court system can respond as well as the federal court system, and just take it for what it is. It might be of interest to you given that question.
I was going to say, fortunately, I'm not a mathematician, but the data that I look at is what the post-Civil War Congress decided. They looked at the data And they looked around and said, we want states to have to answer in federal courts when they violate the Constitution. That's what we want. We don't want them off on their own anymore. And so that, I think, should, I don't even want to say Trump at all, but I will. That should trump it all. Whatever the data is, the data of the Congress, what the Congress looked at it and said, we're changing things around. States, you're not free from the Constitution anymore. You got to answer to federal court. And I have no reason why, or I don't understand why an ordinary person like Miss Knick cannot protect her federal right in a federal court. And I hope the court, and I suspect the court, agrees with that.
Thank you all so much for joining us today. I hope you all join me in the